Well, I guess I'm a little concerned about the potential collapsing of the merits with your argument in this case, because your argument, as Justice Alito pointed out, is premised on the fact that this judgment is actually void, but obviously the person who benefits from the judgment would say it's not. And so some court somewhere, I think, would have to resolve that. And I guess the question is, why should you be able to make that kind of challenge without any sort of procedural limitation in terms of time? Someone has the judgment who's benefited from it, and they are living their lives and thinking everything is fine, and under your rule, that can be upended at any time on the basis of your claim that the judgment is void. Don't we have procedural rules that sort of just limit your ability to make that claim and really don't speak to the issue of whether or not it's actually void? You just have to make that allegation within a particular period of time.
Justice Jackson, I would say that void judgments or judgments void ab initio are within a separate class. And so the Constitution requires that void judgments not be given effect.
Right, but what if we don't know whether or not this is a void judgment? I mean, that's the issue, right? That's the merits claim that you are making when you file this motion. And someone has to decide it. And I guess my question is, what is a court supposed to do? 10 years later, you pop up and say this was a void judgment. Doesn't the court have to decide whether or not it's a void judgment in order to determine whether or not you have filed this in a timely fashion?
Well, yes, obviously you have to make a motion and you have to convince the court that the judgment is void. But if the judgment is void from the get-go, then there cannot be a time limit setting apart res judicata or waiver when that judgment would suddenly spring to life.
I guess my problem is that usually we would decide whether or not you are able to file the motion as a threshold matter before we get to the question of whether you're right about the motion. And you seem to have those inverted.
Well, I think, and to go back, I would say that obviously you have to file the motion. You still have to convince the court that the judgment is void. But there cannot be a time after which that cannot be done. Because if the judgment was a nullity from the beginning, then there is nothing for the court to do other than to determine whether it is void. And if it is void, then the decision of whether it is void is essentially a confirmatory ministerial act.
Mr.